Hello everyone, welcome to the second part of the video on citizenship in India. Now in the first part we discussed the constitutional provision with respect to citizenship, that is under the Article 5, 6, 7 and 8 of the Constitution. We also read that Article 11 empowers the Parliament to make laws regarding citizenship in India. If you haven't watched the part 1 video, the link is given in the description. You can check it there. Now, in this video, we'll discuss the Citizenship Act. What is Citizenship Act, first of all? Like I said, it is passed under the pretext of Article 11 of the Constitution. It determines citizenship to India after the commencement of Constitution, that is after 26th of January 1950. So, any date given here will be counted from 26th of January 1950 only. Now, Citizenship Act talks about acquisition of citizenship by these 5 criteria. We will look them one by one in the video. Similarly, it talks about termination of citizenship again by 3 criteria. We'll look into it one by one. And there are some miscellaneous provisions as well. But coming to acquisition of citizenship. So, the first criteria is by birth, also known as jus soli. So, if a person is born in India after 26th of January 1950 but before 1st of July 1987, they will be citizen of India, no questions asked. The second is if they are born between 1st of July 1987 but before 3rd December 2004, they will be citizen of India if either of their parent was citizen of India. So, their mother or father, if they were citizen of India, that person will be a citizen of India. The third is if the person was born after 3rd of December 2004 and till now, that person will be citizen of India if both of their parents were citizen of India or one parent is citizen of India and the other is not an illegal immigrant. Now, why did the government tighten these norms? The reason for it was India is seeing a lot of immigration, illegal immigration from states, from countries like Bangladesh, Sri Lanka, Nepal, Pakistan, Afghanistan, Myanmar. And as I have told earlier that the resources of the country are limited and it would want that these resources are enjoyed by people who share this common ideology, common political ideology, common social history, common cultural beliefs. And for that reason, Parliament tightened these norms. Because otherwise, imagine someone's parents coming from Sri Lanka and then giving birth to their child in 1987, before 1987, that person is citizen of India. And a person whose parents have been living in India for through generation, and that person is citizen of India. Why should they be treated alike? This was the logic behind Parliament tightening these norms. There are a few exceptions to this. The first exception is a diplomat's children. Since diplomats' children are protected by law, they are not counted under this criteria. So if say an American diplomat's children is born in India, they won't be citizen of India just by virtue of being born in India. Similarly, the exception is against the children of enemy aliens. So children of enemy aliens will not be citizen of India just by being born in India. The second criteria is by descent or jus sanguine. Now here again there is one important date, 10th of December 1992. So if someone was born after 26 January 1950 but before 10th of December 1992, if his father was a citizen of India at the time of his birth, then that person will be citizen of India. But after 10th of December 1992, either of the child's parent can be citizen of India. Okay, so now let's look at some of the intricacies of this provision. So what it basically tells is, if say someone was born to a parent, a father specifically, someone who was born to a father who got their citizenship by descent themselves, their birth must be registered at an Indian consulate within 1 year, either of this date or 1 year of their birth, whichever is later. So that means if someone is born in 1990, let's say, they must be registered in an Indian consulate by 10th December 1993. And if someone was born on, let's say, 1995, they must be registered by 1996. Okay, there's another small provision here that says if a minor child who by the virtue of this section, that is by descent, can be a citizen of India, but they are registered to be citizen of some other country till their age, like till 18th, they can register themselves as citizen of India, but they must do so before 6 months has passed of them turning 18. So that means that they can register themselves as citizen of India till they attain the age of 18 years and 6 months. So this is about by birth and by descent, or just solely and just sanguine. Now coming to the next provision, that is by registration. Now citizenship by registration is a little complex. Okay, there are lots of small criteria here. We need not know all of them, but we must know some important one. So the first one that says is a person of Indian origin, that is a person who was either born in India or whose parents or whose grandparents were born in India or could be citizen of India by virtue of the Article 8, they can register themselves to be citizen of India. How? First of all, they must have been living in India for 7 years. Now this 7 years is divided in two categories. Not two categories, two subparts. The first is they must have been living immediately for 1 year before making an application to be registered as citizen. And the second is that they must have resided for 6 years in India in the previous 8 years. So for example, say someone wants to register themselves as citizen of India. Someone who is of Indian origin wants to register themselves as citizen of India in 2020. Let's say March of 2020. So they must have been living in India from March of 2019 continuously, and also that they must have lived in India for 6 years in cumulatively between 2011 and 2019. The second criteria is if someone is born in India. If someone is married to someone who is an Indian citizen. Now again they can be, so here they need not be a person of Indian origin, but they must have been living in India for 7 years. Again 1 plus 6 by 8. Fine. Now let's talk about people who have been registered as OIC for 5 years. What are OIC? OIC is Overseas Indian Citizen. We will look into OIC in detail later. Do not get panicked over it. So any OIC who has been registered as an OIC for 5 years and who has again lived in India for 1 year immediately before making an application to be registered as citizen of India. And finally, if someone's parents were Indian citizen or the person themselves was an Indian citizen and maybe they renounced their citizenship or it was terminated, they can re-register themselves as citizen of India if they have lived in India for 1 year before making that application. Okay, so here you can see there's this one thing which is common between the first two provision, that is 7 years of residence, or if you're married to an Indian citizen, you have to be living here for 7 years. 1 plus 6 by 8. 1 immediately before making an application in this regard, and then in the previous 8 years you must have lived in India for 6 years. And in the second two case, that is if you're registered as an overseas Indian citizen for 5 years, or if your parents or you were a citizen of India. In that case, you must have lived here for 1 year immediately before making an application to be registered as citizen of India. Also remember that citizenship by registration is prerogative of government. That is, it is not your right. The Act nowhere says that the government shall make them citizen. The Act says that government may make them citizen. Now the next one is citizenship by naturalization. Again here, it is not your right, it is the government's prerogative that they can make you citizen or they cannot. Now here there are some list of criteria mentioned in this act under Schedule 3 of the act. Now I'll tell you some of the criteria. You may remember a few of them, that will be good, but do remember the first one, 1 plus 11 by 14. So it is again in similar lines. You must have been living in India for 1 year immediately before making an application to be registered as citizen of India. And you must have also lived in India for 11 years in the previous 13 years. Sorry, in the previous 14 years. Okay. So that means that a total of 12 years in 15 years, in which 1 year you must have lived here immediately and continuously before making an application in this regard. Okay, and the other criteria are, you must know an Indian language, one that is mentioned in the 8th schedule of the Constitution. You must be of good character, good conduct. You must take an oath of allegiance, and you must also not have made a crime against, like, you must not have broken any law that disqualifies you from being citizen of India. Now, it is up to government. Government may relax all the criteria. If government feels that you are someone who has prominent knowledge in arts, literature, science, government may relax this criteria and make you citizen without you fulfilling any of these conditions. So it is again the prerogative of the central government, not state government, not any government. The only government that can do so is the central government. Now coming to citizenship by incorporation of a territory. Now, as you know, India occupied Sikkim after the independence, and so this act basically allows the government, specifically this section basically allows the government to make those people citizen of India. What it tells is government may issue a gazette notification. So in the official gazette of India, a notification may be issued that so and so people of this territory which we have occupied, who belong to this land, shall be citizen of India from this date. Okay, so the government will specify the date. The government will also specify what criteria is being followed. So they will basically write a name of all the person who will be citizen. That is what at least the act says. It says specify the persons who shall be citizen of India by reason of their connection with the territory that has been occupied. Okay, so this is about the acquisition of citizenship. Now let's come to termination of citizenship. As I said, there are 3 ways by which citizenship can be terminated. The first is if you voluntarily give it up, that is, you renounce it. The second is that is termination of citizenship, that is, if you acquire citizenship of any other country, you will by default lose Indian citizenship, as also told in Article 9 of the Constitution. And the final is deprivation. So this is done by the government because you have done some fraud or broken a law. So renunciation is completely voluntary. However, government may not accept it. Government may not accept it at times of war. So it is not that you tell that you want to give up your citizenship and you lose your citizenship. It is that if government accepts it and it is registered, then and only then you will cease to be an Indian citizen. And when can government not accept? When it is, when we are at war with some country. Fine. The next one is termination of citizenship by termination. What do I mean by termination? As I explained, if you voluntarily accept citizenship of any other country, you will lose Indian citizenship. Okay. Again, government may withhold it. If we are at war with someone, the government may say, okay, fine, right now we are not letting you terminate, like we are not letting you be citizen of any other country. So it is again up to the central government. And the final one is termination of citizenship by deprivation. What do I mean by deprivation? Deprivation is when government is taking a negative action against you. So that is what at least it means in this act. So when can government deprive you of Indian citizenship? Say you have acquired citizenship by registration or naturalization, but it was done by fraud. You gave some false evidence, you gave some false facts. Then government can deprive you of Indian citizenship. Similarly, if you have shown disloyalty to the Constitution of India, you can be deprived. If you have, consorted with the enemy during times of war, you can be deprived of Indian citizenship. Say you have gained Indian citizenship by naturalization, and within 5 years of this naturalization, you have been jailed for a period of more than 2 years. You will lose the Indian citizenship again. So there are such laws where citizenship can be lost by deprivation. Remember these 2-3 points, like if you have acquired citizenship by fraud, or if you are jailed within 5 years of naturalization, or if you have consorted with enemies, traded state secrets, or you have shown disloyalty to the Constitution. There are some more provisions regarding it. We may not remember all of them. Now coming to some miscellaneous provisions. The first one is addition to this act on account of Assam Accords. What are Assam Accords? So as you would know that there was huge exodus of refugees from Bangladesh, especially to the region of Assam. The reason for that exodus was that they were being prosecuted. Bengali Muslims were being prosecuted. Remember, Bangladesh was earlier East Pakistan. So Pakistan had control over the polity of Bangladesh as well. And there was prosecution going on. So these people, they fled from Bangladesh, the modern Bangladesh, and the then East Pakistan, and came to Assam. The number was significantly high, and for that reason there was huge uproar in Assam that these people are taking away our rights, our benefits. Because obviously, if say your population is comprising of 30 or 40% immigrants from a neighboring country, you will feel threatened that what if they vote to someone they want and not, it is not in line with our aspiration. So there was huge uproar in Assam, and there was this faction called Assam Student Union. I don't remember the full form right now. So they started large-scale protest against this, and there was violence in Assam as well. And for this reason, in 1985, Assam Accords were signed. Now, what does Assam Accords say? Assam Accords said, basically, Assam Accords led to this addition to the Citizenship Act, and it basically told that those people who migrated to India, those people who were of Indian origin and migrated to India before 1st of Jan 1966, they will be citizen of India again, no questions asked. Okay, if they have been residing in India, they will be citizen of India. There's no issue. Fine. And then it divided, from, if someone came to India, like Assam, from Bangladesh after 1st of January 1966, but before 25th of March 1971, they will have to be living in Assam for 10 years after they have been detected to be a foreigner. And after that period of 10 years, they will be registered as citizen of India. Now, during that time of 10 years, they will not get voting rights. They'll get other rights, but they will not get voting rights. Why was this? Because, like I said, the people of Assam, they felt threatened that the voting pattern, the government of the state will get influenced by these migrants. The act further goes on to say that anyone who comes after this 25th of March 1971, they will not be a citizen of India. So they will not be treated as citizen of India if you have migrated to Assam after 25th of March 1971. Now, coming to concept of overseas citizen of India or overseas Indian citizen. So this is basically a concept that was floated in 2002. What it means that any person who is citizen of another country but was a citizen of India or was eligible to be a citizen of India at the time of commencement of the Constitution, such a person can register themselves as overseas citizen of India. Okay. Next one is if someone is married to an Indian. Okay, if you are married to an Indian and you have the marriage has stood for 2 years, more than 2 years, you will be a citizen of India. The next one is if you're child of a person or grandchild of a person or a great grandchild of a person who was a citizen of India or could have been a citizen of India by the criteria specified in the Constitution at the commencement of the Constitution, such person will be a overseas citizen of India. And finally, a person who is minor child of a person mentioned in these two criteria, that is a person who was ever citizen of India or was eligible, or a person who is child, grandchild or great grandchild, such person can also register themselves as a citizen of India, overseas citizen of India. Now, what are the benefits of overseas citizen of India? So the benefits given to overseas citizen of India is that they get almost all the rights except those specified in these acts. Now, what are some of the rights which have been specified in the act? So they are Article 16. What is Article 16? Article 16 talks about equality of opportunity in matter of public employment. They cannot contest the election to president, vice president. They cannot be judges of Supreme Court or High Court. They cannot be a voter. And if you're not a voter, you cannot be a representative of any of the house. So this is regarding the concept of overseas citizen of India. Now you would know that after this, the government also came with this another concept of people of Indian origin. However, recently by Mr. Modi, these two card holders have been merged, that is person of Indian origin and overseas citizen of India. They are one. They are known as OCI card holder only, and all the entitlements have been at par. This was done because there was some confusion. Some people were like, am I PIO? Am I OCI? And for that reason, these cards were merged finally. I don't remember in which year. I can look it up for you. There's a notification in PIB as well regarding this. One sec. Yeah, so it has been done in from January 6, 2015. There was an ordinance promulgated in this regard, and later the law was passed that OCI and PIO will be merged. This was a long-standing demand of Indian diaspora abroad. And before I end this video, I would also like to tell this one small thing. What do you understand by NRIs? So NRIs are people who are Indian citizens. They hold Indian passport, but they're not living in India. So basically NRIs are citizens of India. They have voting rights. They have all the rights that are given to Indian citizens. The only thing is they are not living in India. I'll just give you a quick recap of Citizenship Act. First of all, it talks about acquisition of citizenship and termination of citizenship. Second, it talks about in the acquisition of citizenship, it talks about citizenship by birth or jus soli, citizenship by descent, jus sanguine. Then it talks about citizenship by registration, by naturalization, and by incorporation of new territory. By registration, naturalization, and incorporation of new territory, it is government's prerogative to give you citizenship. Further, there were some criteria we discussed regarding registration, naturalization. In registration, remember 1 plus 6 by 8, and in naturalization, remember 1 plus 11 by 14. And then we talked about how you can lose citizenship. In that, by renunciation is fairly simple. If you voluntarily renounce Indian citizenship, By termination is simple if you voluntarily take up citizenship of any other country. However, in both these cases, government may withhold if we are at war. By deprivation, as I said, if you have gained the citizenship by fraud, or if you have insulted the constitution, or you have consorted with enemy states by trading our secrets, etc. And then finally, we talked about citizenship to people who migrated from East Pakistan to Assam. There we had to make certain real changes because there was huge protest going on in Assam. There's large number of migration. So if you migrated to India before 1st of January 1966, you will be a citizen of India, fine. But if you migrated to India after 1st of January 1966 but before 25th of March 1971, you must live for 10 years in India, and then you must also be registered as a foreigner, and it is then and then only that you will be given an Indian citizenship. There's no clause of granting Indian citizenship to those who came after 25th of March 1971. So they cannot be citizen of India by provision of Citizenship Act. And finally, we talked about the overseas citizen of India. We talked about some of the criteria and some special rights they get compared to any other foreigner who comes to India. And we also mentioned how PI, Person of Indian Origin card, and OCI card has been merged together. Okay. Well, this is the end of this video. In the next video, we'll talk about the recent issues surrounding Citizenship Amendment Act. Till then, have a good day. Thank you.